Next speaker is Professor Trebach. Way back when I started in this and tried to get smart about all of this, it was Professor Trebach that was out there leading the charge. I was just thinking, sitting over here, and I was thinking, boy, you know, Arnold has connected the United States up with Europe academically in this thing through the Drug Policy Foundation that he started, and he's just connected with so much. John's talking about the petition that we're working on, and he had something to do with that too. He's like he's everywhere. Come on up, Professor, and tell us everything. Professor Arnold Trebach.
What we must remember about those hearings is we mustn't forget them. These were the most dramatic, extensive analysis of any drug in a judicial or quasi-judicial situation in the history of mankind or womankind. Judge Young sat up there, and remember, he was the chief administrative law judge. He sat up there in his robe, and we brought in, I guess it must have been 10,000 documents, however, I mean, I'm sure they'd reach up to here, all right? And witness after witness, including Dr. Petro, all kinds of witnesses, and Judge Young sat there, and we agreed that the principles would be whether the marijuana plant considered as, this is in my handout so you can look at it, considered as a whole may lawfully be transferred from Schedule 1 to Schedule 2, and we agreed on two subsidiary issues. By the way, this is legal strategy. As lawyers, you should narrow the issue. And whether the marijuana plant has a currently accepted medical use and treatment in the United States or a currently accepted medical use with severe restrictions. Two, whether there is a lack of accepted safety for the use of the marijuana plant under medical supervision. Now, all during the trial, which went on and on and on, we felt kind of at a disadvantage. Now again, we're good lawyers. We're used to batting heads. I mean, my specialty was walking out in the hall and saying to the DEA lawyers, come on, Joe, you don't believe that bullshit, do you? What you just said in there? And other things of that nature, all right? However, we did play the game straight on before Judge Young and always felt that he was down on us. He was impolite. He was rude. He was objective, but anytime he could give us a nudge, he would, all right? Now, again, there were other times he was kind to us. At any rate, we were not happy about looking for the decision. Remember now, he was even though he was in a black robe, and we were in what could be called a courtroom, he was an employee in the executive branch. And that executive agency he was in was DEA. He was paid by DEA. We were stunned. As you all know, the decision came out on our side. He agreed with us on almost every word, and we've just seen the decision which Valerie put up. And in effect, he said, the administrative law judge recommends that the administrator, that is the head of DEA, conclude that the marijuana plant considered as a whole has a currently accepted use in medicine in the United States, and that there is no lack of accepted safety. And he went on to say the judge recommends that the administrator transfer marijuana from Schedule 1 to Schedule 2. Normally, when an administrative law judge, especially a chief administrative law judge, makes that recommendation, that's it. It's 99.9%, because the administrative law judges make most of the decisions in the federal government. Remember, Judge Young was the only person in history in a quasi or judicial role who heard all the evidence on one drug, and it was extensive. We brought in all of our witnesses. They brought in all of theirs. It was a fair, open hearing. You know, when I'm being ingracious, I like to point out to hostile audiences, it was like, you know, the Red Sox played the Yankees in Yankee Stadium, and the Yankees hired the umpires, and we whooped their ass. At any rate, now, just a second, I'm looking here. it was important that we recognize how Judge Young came up with the idea of accepted medical use. The standard approach within DEA, and they've used it before, was that if the FDA did not approve it, then there's no medical use. Judge Young's position, and that I think of good law, is that you determine medical use by looking at what doctors and patients say. That's where May Nutt came in. That's where Dr. Petro came in. We put in a whole lineup of doctors and patients. And in the end, the judge said this. He placed great legal emphasis on patients. Quote, doctors accept a therapeutic agent only if it works for the patient. Unquestionably, patients in large numbers have accepted marijuana as useful. They have found it works. So all your work has legal significance, not just scientific significance, according to Judge Young. Because the way you find out how something works is you look at what the doctors say. Now, remember this, speaking legally, there are analogies to this in the law. Medical malpractice cases here and in other countries. In other words, when I was involved in the cases in the UK, I studied the entire Western world on how you judge acceptable medical behavior. And there's a standard. If a medical practice is accepted by, quote, a respectable minority of physicians, close quote, it should be appropriate for that particular doctor to use it. If you doctors are ever sued for medical malpractice, that easily would be your defense, all right? Now, so Judge Young was applying something that's very familiar in the law. And what happened, though, of course, was that the head of DEA, who had the power to do it, John Lawn, came down with a decision that practically accused Judge Young of being corrupt and a crook, and the rest of us is just being a bunch of hippie nuts. So that, unfortunately, the reason why Judge Young's decision doesn't work today is that it was overturned by the administrative law judge, and all the appeals that John was talking about upheld the decision, the decision of the head of DEA. Under the Chevron case, and it's a good rule, if there is a reasonable basis for a decision, an administrator, head of an agency, will have that decision not overturned by the federal courts. And yeah, there is a basis for the other side, let's face it. He had lots of witnesses. However, his decision was easily, Judge Lawn's decision, the head of DEA's decision, was the worst legal opinion I've read in over 50 years of practice. It was scurrilous. It was beneath dignity. We must face up to the fact, a number of things. First, you should use Judge Young's decision wherever it could do you some good. It is brilliant. It is right to the point. It says, oh, by the way, it came out on two grounds very solidly, that there is evidence that it works in dealing with cancer patients and with spasticity. Now, the wonderful thing is that as you have documented, this is moving forward. We are moving, the ground under the feet of people who oppose this. And hopefully we'll come back to Judge Young's decision and make it law. In the law, speaking purely as a lawyer, what happens in the law sometimes is that as time passes and as opinions change, a dissent becomes a majority of opinion in a case, in the Supreme Court. So keep Judge Young's opinion alive, and in time, in other fora, it is conceivable that it will become the majority rule.